Hello everyone, and welcome to this session on corporate laws and practice. Let's dive into the fundamentals of the Companies Act, 2013. This act serves as India's comprehensive legal framework for companies, comprising 470 sections and 7 schedules. It was enacted to replace the 1956 Act, with the goal of modernizing corporate law in line with international best practices. The Act governs everything from the incorporation and day-to-day regulation to the eventual dissolution of companies in India. It lays down procedures for corporate governance, financial reporting, and mandates things like annual general meetings and statutory filings. Key provisions include the concepts of corporate personality, limited liability for shareholders, and the structure and powers of directors. A significant emphasis is placed on transparency, accountability, and protecting all stakeholders. It even addresses corporate social responsibility, or CSR, under Section 135, requiring certain companies to allocate a portion of their profits to social welfare. So, what exactly is a company? Essentially, it's an association of persons. From the moment it's incorporated, it gains its own legal identity, allowing it to own, acquire, and transfer property in its own name. A core concept in company law is the limited liability of its members. This means a member's financial responsibility is restricted. For a company limited by shares, liability is confined to the unpaid amount on the shares they hold. In a company limited by guarantee, liability is limited to the specific amount each member undertakes to contribute to the company's assets, especially if it were to wind up. Let's explore some different types of companies, starting with those based on liability. We have companies limited by shares, where members' liability is only for the unpaid amount on their shares. Then, there are companies limited by guarantee, where liability is capped at the amount members promise to contribute if the company winds up. If it also has share capital, that liability includes both. And finally, an unlimited company, where members have no cap on their liability. Next, we differentiate between government and non-government companies. A government company is one where the government holds 51% or more of the paid-up share capital. Any company not meeting this criterion is classified as a non-government company. Continuing our look at company types. First, we have holding and subsidiary companies. A holding company is essentially one that controls another, either by dictating its board composition or holding over half of its total voting power. Then there's a small company. This is not a public, holding, or subsidiary company, and it has a paid-up share capital not exceeding 10 crores, with a specific turnover limit from the preceding financial year. Companies registered under Section 8 are non-profit organizations, established for charitable or promotional purposes. Finally, the one-person company, or OPC, which requires a nominee. This nominee must be a resident in India, meaning they've stayed in India for more than 182 days in the immediately preceding financial year. Now let's talk about the Memorandum of Association, often called the MOA. This is the fundamental and first crucial document a company must create and file with the registrar during incorporation. It truly lays down the company's constitution, acting as the very foundation of its structure. The MOA clearly states the company's powers and objectives, defining the scope of its operations. It's prepared to give shareholders, creditors, and any external party a clear idea of what the company is authorized to do. It provides vital information such as the company's name, its registered office, its main objects, capital, and the limits of its members' liabilities. The MOA is also known as the charter of the company. Once registered, it becomes a public document, meaning anyone dealing with the company is presumed to know its contents. It contains 6 essential clauses: name, registered office, object, which is arguably the most important, defining the company's purpose and activities, and then liability, capital, and subscription. It's important to remember that the MOA is subordinate to the Companies Act itself. To make alterations, a special resolution is typically needed at an annual general meeting, and sometimes prior approval from the central government is also required. A key point is that the MOA cannot be amended retrospectively. Regarding acts performed beyond the scope of the memorandum, these are considered, ultra vires acts. They are void, have no legal or binding effect, and cannot be ratified. In essence, the MOA defines the company's relationship with outsiders. Next, we have the Articles of Association, or AOA. This is the second crucial document filed with the registrar at incorporation. While the MOA is external, the AOA is your company's internal rulebook. containing the guidelines for its governance and administering its internal affairs, including the powers and duties of directors and officers. The AOA is subordinate to the Memorandum of Association and must not contradict the Companies Act. It essentially forms the basis of a contract between the company and its members, and also between the members themselves. Its contents cover a wide range of internal rules, such as those concerning share capital, the rights attached to shares, calls on shares, and the transfer and transmission of shares. The Companies Act contains specific provisions where a company can only act if authorized by its articles. Alterations to the AOA can be made by passing a special resolution at the AGM. Unlike the MOA, the AOA can be amended retrospectively. Central government approval is sometimes needed, especially for converting a public company into a private one. Now, if an act is beyond the scope of the articles, but still within the scope of the MOA, it can actually be ratified by the members. This is a crucial difference from MOA ultra vires acts. The AOA primarily defines the relationship between the company and its members, and among the members themselves. Let's look at the key regulatory bodies governing companies in India. First, the Registrar of Companies, or ROC. The MOA and AOA are filed with the ROC at incorporation, and they oversee all corporate compliance, requiring various reports and resolutions to be filed by directors. Then we have the National Company Law Tribunal, or NCLT, which is responsible for adjudicating matters related to companies. The National Company Law Appellate Tribunal, or NCLAT, serves as the appellate body for decisions made by the NCLT. Finally, the central government plays a significant role, particularly in approving certain corporate actions, like alterations to the Memorandum of Association or the conversion of public companies into private companies. Moving on to the powers of directors. Directors hold broad authority, which is regulated by the Companies Act 2013, to manage various company situations. Let's break down some of their key powers. In terms of financial and capital powers, directors can make calls on unpaid money on shares, authorize share buybacks, issue new shares or debentures, borrow money, approve financial statements, and even declare interim dividends. Operationally and strategically, they can bring changes to the Articles of Association, diversify the company's business, approve mergers or acquisitions, and frame policies, rules, and procedures for smooth business operation. They also control and supervise the work of subordinates. Directors also have significant appointment and removal powers. They can fill casual vacancies for directors, appoint the company's first auditor, appoint whole-time directors and managing directors, remove key managerial personnel, and appoint managers and company secretaries. Other notable powers include making political contributions, canceling or leasing company assets, demanding repayment of loans, and entering into contracts with third parties on behalf of the company. Beyond powers, directors also have crucial duties. Their fiduciary and ethical duties include acting according to the Articles of Association in good faith and always in the best interest of the company and its members. They must exercise their duties with due care, skill, and diligence, and exercise independent judgment. It's critical that they avoid situations that conflict with the company's interest and not gain any undue advantage for themselves or their relatives. Furthermore, they cannot assign their office or responsibilities to others. From a disclosure and compliance perspective, directors must disclose their shareholding, attend AGMs and other company meetings, ensure full and correct disclosure in the prospectus, and sign the prospectus before it's filed. They are also responsible for filing various reports and resolutions with the registrar and performing all other duties outlined in the Act. Thank you for joining the session.